Chris Brown has just been ordered to pay his former housekeeper nearly $13 million after she was mauled by his dog, but he's not accepting the verdict. Instead, the singer is reportedly losing it in court, demanding a new trial and trying to have the entire case thrown out. But things aren't exactly going his way. Let me break it down. The man who refused to accept the verdict. On Tuesday, June 30th, 2026, inside a Los Angeles Superior Court in Van Nuys, Chris Brown was hit with a massive verdict. The jury found Chris Brown and his company, Black Pyramid LLC, liable for negligence over a dog attack that happened more than 5.5 years earlier. Then they attached the price tag, $12.9 million to Maria Avila, the former housekeeper who was mauled, $885,000 to her sister Patricia, who found her bleeding on the ground, $50,000 to Maria's husband, Oscar Olivo, for loss of consortium. Added up and you land at roughly $13.835 million, $13.8 million over a dog. Now here's where the story stops being a headline and starts being something stranger, because most people, when a jury hands down a number like that, do one of two things. They pay it, or they quietly negotiate it down behind closed doors while their publicist says absolutely nothing. Chris Brown did neither. Chris Brown went the other way entirely. He went to war with the verdict itself. The formal judgment was entered on July 16, 2026, roughly 2 weeks later, right at the turn of the month between July 31st and August 1st. Brown and Black Pyramid LLC filed a notice of intention to move for a new trial in Los Angeles Superior Court. Not an apology, not a payment plan, a demand that the entire trial be thrown in the bin and started over from scratch. Understand what that actually means, because the phrasing does a lot of work to hide how audacious it is. A motion for a new trial is not an appeal. An appeal says a higher court should review whether the law was applied correctly. A motion for a new trial says something far bolder. It says the process itself was so broken that the result cannot be allowed to stand, and that the only fix is to impanel 12 new strangers, put every witness back on the stand, and make Maria Avila tell the story of the worst day of her life all over again from the beginning. 5.5 years of waiting, and the proposal on the table is, let's run it back. And the grounds he's arguing on are the part that made people's eyebrows climb straight off their foreheads. His attorneys are challenging the verdict on 4 fronts: irregularity in the proceedings that prevented a fair trial, jury misconduct, insufficient findings supporting liability, and excessive damages. 4 separate arguments, all pointing at the same conclusion: that the 12 people who sat through the evidence, looked at the scars, and returned that number somehow got it catastrophically wrong. Sit with the second one for a second: jury misconduct, because that particular complaint has an echo in this case, and the echo is loud. Rewind to mid-June 2026, weeks before the verdict. The trial had already started. Jury selection had already happened. And then the whole thing collapsed. That mistrial didn't come out of nowhere.
Now, yesterday in court, Chris Brown is leaving court because there was a mistrial that happened in the courtroom.
And it didn't come from anything Brown's side did wrong. It came from inside the jury box itself, from a single person who couldn't resist going online.
A juror was searching for information about the case before the trial, started also sharing that information that they were searching with other people.
A juror had researched the case online and shared what they found, and the judge declared a mistrial. A brand new jury was seated, and the trial restarted. So when Brown's legal team now raises jury misconduct again as a reason to scrap the second jury's verdict, they are reaching for the same lever that already worked once. That is not a coincidence, that is a strategy. And the way Brown carried himself walking out of that courthouse after the mistrial tells you exactly how he was reading the situation at the time.
You're looking good too. I see you're walking out feeling, how are you feeling about it? Because it was a mistrial.
He was loose, he was smiling, he was complimenting the photographer's outfit. Whatever weight this case was going to eventually put on his shoulders, he was not carrying it that night. And his answer to the biggest question of the moment was 4 syllables long.
Man, what happens?
Do you feel like this is a cash grab situation? I mean, she's asking for like $90 million.
That framing, the cash grab framing, is the one his supporters would end up running with for the next year. And it's the same instinct now baked into the excessive damages argument in his new trial motion. But listen to how he handled it in the moment. No denial, no defense of the dog, no mention of the woman at all. Then he pivoted to the thing that actually mattered to him.
It's crazy. God bless everybody though.
Which was the money he had coming, not the money he might owe.
Oh, thank you.
I hope you have a wonderful night.
Okay, is there anything you can tell the fans?
Yeah, get ready for that tour.
Get ready for that tour. Remember that line, because the tour is about to become the single most important object in this entire story, and not for the reason he meant. The R&B tour, Brown co-headlining stadiums, with Usher, promoted by Live Nation, officially launched on Friday, June 26, 2026, at Empower Field at Mile High in Denver. Enormous production, roughly 2 million seats put on sale, the kind of run that turns a calendar year into to a fortune. The jury delivered its verdict on June 30th. That is 4 days. 4 days between the first stadium show and the moment a Los Angeles jury told him he owed a housekeeper nearly $14 million. Contemporary reporting from outlets including Variety and Billboard explicitly flagged that overlap, because in the world of civil judgment collection, timing like that is not a footnote, it's a target. And then came the detail that turned this from a legal story into a chase. Brown didn't pay. Not a portion, not a gesture, nothing. In late July, Maria Avila's attorney Nancy Dumanian filed court documents stating that Brown and Black Pyramid LLC have made no effort to satisfy any portion of the judgment, and that repeated attempts by her team to communicate with Brown's lawyers about payment had simply gone unanswered. Silence. Total strategic silence. While interest kept stacking up on the unpaid balance under California law at roughly 10% a year, reported as somewhere around $1.38 million annually, or about $3,800 for every single day, the judgment sits there untouched. $3,800 a day while he's on stage, while he's asleep, while he's filing paperwork asking for a do-over. So Avila's team stopped waiting politely. They asked the court to order Brown to sit for a judgment debtor examination, sworn questioning about his income, his bank accounts, his investments, his property, his royalties. They asked to compel production of financial records showing exactly how much he's being paid from the tour with Usher and whether that money flows to him directly or through one of his companies. And most aggressively of all, they asked the court to freeze accounts tied to the tour so a slice of the profits could be walked straight across to the woman his dog put in a hospital bed. Which brings us to the question everybody skipped past in the rush to argue about the number. What actually happened at that house on December 12, 2020? Because the jury heard it in full. And once you hear it the way they heard it, the $13 million starts to look very, very different. The driveway, the dog, and the man upstairs. Tarzana, Los Angeles, a gated property in the hills. The records in the case reference the address as 19,602 Citrus Ridge Drive, and on this particular Saturday, it had 2 housekeepers working inside it. Sisters, hired around November 2020, with Maria having worked at the house only a limited number of times.
I don't know.
That's
This lady said that she alleged that she was just cleaning the home, she was taking the trash out.
It was an ordinary shift doing ordinary work, and the thing that ended it was as mundane as it gets. That's the whole setup. She stepped outside to empty a vacuum bag. She bent over, and somewhere in that yard, something enormous was already moving toward her. The dog's name was Hades. He was a Caucasian shepherd, also called a Caucasian ovcharka, a guardian breed with a history of being used for protection work, including in Russian security and prison contexts, and trial accounts consistently described him as weighing around 200 pounds. 200 pounds. That is heavier than most grown men. That is a bear with a collar on. Maria never saw him coming. Testifying in Spanish through a court interpreter, she described the moment as something she felt rather than something she saw. I didn't see it, I simply felt it. It was something really big. What followed was not a bite, it was a mauling. The dog went for her face, her hand and arm, and her foot, tearing away large chunks of skin. She screamed. She called out for help. She testified that she believed she was going to die, and her memory of those seconds survives only as fragments, flashes, not a sequence. Patricia heard the screaming from inside, recognized the voice as her sister's, and ran out to find Maria covered in blood, crying for help. She held her, and later described being certain that Maria would not survive. Now here is where Chris Brown enters his own story, and where the jury's opinion of him almost certainly began to harden. By his own testimony at trial, Brown was upstairs getting ready to shower when he heard Hades growling. He came down and found Maria face down and motionless on the concrete outside the front door, with, in his words, a lot of blood. He said the blood freaked him out. He said he was in shock. He secured the dog in a kennel. He crouched down close enough to watch her chest move so he could confirm she was still breathing. And then he yelled for a member of his security team to come and get help. What he did not do is the part that stuck. He never touched her. He never offered her water, a towel, or any physical comfort, and he did not dial 911 himself. He explained why. That's the extraordinary part. He explained why, out loud, on the stand, under oath. He testified he was worried that a recording of the emergency call would leak to the press and create a media circus because of who he is. So a security guard made the call instead, while Maria stayed on the ground, bleeding, and then he left. Brown testified that his manager advised him to get off the property before first responders arrived. The stated goal being to make sure she was taken care of and to get me away from the publicity. He followed the advice, left while she was still lying there, and drove around for several hours until he was told it was safe to come back. When Avila's attorney pushed him on the obvious question, why not just stay with a bleeding woman in your own driveway until the ambulance arrives? He answered, because of how my image is and always used. I didn't want a misleading story or like a circus from my status. It's pretty sticky when it comes to that, so me staying out of the way was advised. Meanwhile, from where Maria was lying, none of this looked like a rescue. She testified she had only ever seen leaving Brown's smaller dogs, French bulldogs, on the property, that she had no idea Hades was loose that day, that she never saw anyone secure the dog, and that mostly what she heard was a car leaving. Her daughter later testified about the frantic phone call describing Maria unable to breathe, repeatedly passing out, an ambulance that hadn't arrived, and Brown gone. Brown's central defense was that he had warned them. He told the jury he personally told both sisters that the dogs were absolutely not friendly and that they should not go outside without security present, and that he delivered this warning in English, and that the women said, okay. He used it to argue Maria was partly at fault for stepping outside alone. Both sisters denied that conversation ever happened. Their attorneys pointed at the language barrier. Both women are Spanish speakers. Maria testified through an interpreter for the entire trial, and the warning Brown described was in English, meaning that even if it had occurred exactly as he said, they wouldn't have understood a word of it. Then there's what happened to the dog. Hades was removed from the property after the attack. Roughly 12 days later, he was found roaming rural Humboldt County in Northern California, hundreds of miles north, and was euthanized by the county sheriff's animal shelter. Animal control notes indicated the dog had been declared dangerous in Los Angeles. Brown testified Hades wasn't his personal pet at all, but a security animal bought and handled by his team because, in his words, he gets a lot of stalker-type situations. And it wasn't the first time authorities had looked at animals on that property. Los Angeles Animal Services records obtained by CityWatch LA revealed that the Permit and Animal Cruelty Unit had conducted a prior investigation involving 2 pit bulls at the residence before the December 2020 attack. Now the injuries, because this is where excessive damages collides with reality. Surgeons harvested skin from Maria's abdomen to graft onto her mangled arm, and the donor site left her unable to bend at the waist for a significant period of her recovery. Her facial lacerations required dozens of sutures. She spent 5 days in hospital completely alone because COVID-19 restrictions barred family visits. More than 5 years later, she brought the evidence into the room with her hands visibly shaking. She walked to the jury box, rolled up her left sleeve so jurors could see the raised and pitted skin covering much of her forearm, then removed her glasses and swept back her bangs to show the pattern of scars running from beneath her left eye up across her forehead. She told them she lives with permanent nerve damage and chronic sensitivity on her left side that disrupts her sleep and her ordinary daily tasks. Partial vision loss. Arm strength so reduced she can no longer scrub a floor or wring out a mop, and severe post-traumatic stress including a fear of all dogs, which since most of her former clients keep pets, ended her career entirely. Her daughter, Yoseline Espinoza, testified that her mother used to have a spark, dressing up, wearing makeup, caring about how she looked, and that afterwards she stopped, started avoiding public settings and family outings, hated having her picture taken, and didn't want people to see her face. And through the interpreter, Maria gave the jury the sentence that every outlet in the world would eventually print. She said she will never be the same again. The jury rejected Brown's version of the warning entirely. They found him and Black Pyramid LLC liable, and they awarded the full damages without reducing them by a single dollar for any comparative fault on Maria's part. No discount, no partial blame, nothing. The do-over, the money hunt, and the pattern. So now you understand the evidence. And now you can properly appreciate what it means that Chris Brown's response to all of that was to ask a judge to erase it and run the whole thing again. The hearing on his notice of intention to move for a new trial is scheduled for September 22nd, 2026. At that hearing, the court can grant a full new trial, deny it outright, reduce the damages, or take some other action. As of early August 2026, no judge had ruled on the merits. No interim order tossing or staying the judgment had been reported, and the roughly $13.8 million remained fully in effect while interest kept running. The September 22nd date also happens to fall neatly between tour stops between the Las Vegas and Los Angeles shows, and this fighting posture isn't new to the case. It's been the whole case. Back in early 2025, during discovery, Avila's lawyers accused Brown of stalling his own deposition for months. His newer legal team informed them he had relocated from California to Nevada and therefore couldn't be deposed in California. And Avila's side said Brown's previous lawyers had never told them about the move at all. His attorneys denied deliberate evasion, citing his touring schedule and his out-of-state residence, and said they'd offered to have him deposed in Nevada. Avila asked for $7,560 in sanctions. In late March 2025, the judge ordered him to appear in Los Angeles by the end of April, and he sat for the deposition on April 30th, 2025 for about 5.5 hours, after which her team accused him of being evasive on topics like surveillance systems and dog ownership, delay, deny, dispute, and when the verdict lands, demand a new trial. The pattern is remarkably consistent, and it's not confined to this lawsuit either. Brown separately sued Warner Bros. Discovery and the production company Ample Entertainment for $500 million over a documentary he claimed defamed him.
And the lawsuit was a defamation lawsuit for $500 million.
And that one went the same direction as everything else. $500 million aimed at a documentary. His argument was that the film had misrepresented him from top to bottom.
Brown is basically alleged then that the doc was full of lies and deception.
A judge disagreed, finding the documentary had met journalistic standards and fairly presented both sides, including the inconsistencies Brown's own team had flagged.
They don't see defamation. Defamation is very hard to prove, by the way. But the judge is not agreeing with Chris Brown in this one.
Meanwhile, on the other side of the Atlantic, an entirely separate legal storm was reaching its own conclusion, and this one was criminal, not civil.
Okay, so I am outside Southwark Crown Court here in London near London Bridge.
This was July 24th, 2026, less than a month after the dog verdict, and it concerned a night at a Mayfair members club 3 years earlier.
The civil trial with LA and, the dog that mauled his keeper's face, that was a civil trial happening in LA.
2 cases, 2 continents running in parallel. In the early hours of February 19, 2023, at Tape London in Hanover Square, prosecutors said Brown struck music producer Abraham Diaw twice over the head with a glass tequila bottle, that his vocal coach and co-defendant Omololu Akinlolu joined in, that the assault continued as Diaw tried to flee, and that Diaw was kicked while on the floor before being treated at St. Mary's Hospital for head and knee injuries. The Crown Prosecution Service did not describe it gently.
There is so much, guys, happening at the same time, and I honestly I'm so perplexed.
The statement went further, spelling out exactly what the prosecution said the bottle was used for that night.
By all of this, but I think this was a good move on Chris Brown's behalf. So I really wanted to make this video because the blogs right now are discussing everything in regards to this court hearing.
He was arrested in Manchester in May 2025, charged with attempted grievous bodily harm, actual bodily harm, and possessing an offensive weapon. He initially pleaded not guilty and was released on £5 million bail so he could keep touring. Then on July 24th, 2026, he and Akinlolu both pleaded guilty to the lesser public order offense of affray, and the more serious charges were dropped.
But I think that this was a clever move because now this basically means there's going to be no criminal trial.
Clever, maybe. But the reporting from outside the courthouse that day was careful not to confuse a tactical plea with an acquittal.
I'm not saying the man is innocent. I'm not defending his actions. He was wrong for doing so. So was his alleged friend. So was his co-defendant, sorry. Both of them were wrong for assaulting somebody.
Sentencing is set for October 26, 2026. Affray carries a maximum of 3 years, and the judge said all options remain open. Diaw's separate $16 million civil suit in Los Angeles was dismissed with prejudice in July 2025. It can never be refiled, and no settlement was ever confirmed. So here's the calendar Brown is currently living inside. September 22nd, a Los Angeles judge decides whether his $13.8 million verdict survives. October 26th, a London judge decides whether he walks free or goes to prison. And in between those 2 dates, he is expected on stage in stadiums most nights of the week, which raises the question that makes the excessive damages argument so hard to sell. Can he actually afford this? Pollstar's late July 2026 rankings place Chris Brown and Usher at #1 among global tours by average gross per city, an average gross of $7,826,586 per city, average attendance of 42,795, and an average ticket price of $182.88. One strong city, nearly $8 million. Before you even discuss the rest of the run was expanded from around 33 dates to 51 or more, and was already about 90% sold before the first show. For scale, his 2025 solo stadium run, Breezy Bowl XX, grossed $295.5 million across 49 shows, and his overall net worth is estimated at around $85 million as of mid-2026. Gross is not take-home. Promoter fees, venue costs, production, crew, security, support acts, commissions, and taxes all come out first. But even after all of it, the arithmetic is not subtle. This judgment is payable comfortably, which is why Avila's team is no longer asking nicely. Under California law, judgment creditors have serious tools: debtor examinations under oath, bank account levies, assignment orders redirecting tour guarantees, royalties, licensing, merchandise, and sponsorship money straight to the creditor, liens on California real estate, and contempt sanctions for defying collection orders. And Brown's public response to all of it? On Wednesday, July 29, 2026, days after the filing that sought to freeze his tour accounts, he posted a text on black screen Instagram story reading, "Life gonna always push and pull you in different directions. Just remember WHOUR, trust the process." No caption, no context. Fans and outlets immediately immediately connected it to the case, though he never confirmed anything. And to this day, he has made no direct public statement about the verdict itself, with his representatives declining media requests and his legal team speaking only through filings. The internet split down the middle. Supporters called $13 million excessive for what they framed as just a dog bite and defended his right to fight it. Critics called it karma, pointed to the 2009 felony assault on Rihanna, and emphasized that this was not a nip, it was a mauling that left permanent disfigurement, and he left the scene while she bled. That record is long. The 2009 felony conviction and 5 years probation, repeated violations including 131 days in jail in 2014, and the 2016 armed standoff arrest at his Tarzana home, plus the 5-year restraining order granted to Karrueche Tran in 2017, over allegations he denied. Maria Avila waited 5.5 years for 12 strangers to say she was telling the truth. Her attorney said afterwards that no amount of money can restore what was taken from her client or erase what she's been through. And on September 22nd, a judge will decide whether all of it gets thrown out and started over from zero. Thank you for watching. If you enjoyed watching this video, click on one of the boxes playing on your screen to watch more similar content.